Okay, so good afternoon. As indicated, my name is Judge Ruth Garrett. I'll be hearing your cases this afternoon. This is case number 21354-927. It is, want to enable the waiting room. It is Connie Porter versus Whitney Wyndham, Kyla Roberts. And then I have a counter complaint, Whitney Wyndham and Kylie Roberts versus Connie Porter. Good afternoon, counsel. Name for the record. Attorney Snow.
Yes.
Good afternoon.
Yes, Your Honor. Charlene Snow from United Community Housing Coalition, P26923, on behalf of defendants.
Okay, so good afternoon. Today was supposed to be set for a trial. My court clerk has informed me that the plaintiff couldn't make it today, couldn't get off from work. Is that correct?
Well, Your Honor, I don't know what's correct. I do know that she emailed me, Miss Porter emailed me at 12:11 this afternoon to tell me that she was not going to be here. She states, after saying a few things about my client that I'm not going to read into the record, I will not be at court today. I can't get time off work for this court situation. I'm a general manager and I can't get this time off. The attorney I retained cannot represent me today due to personal family related reasons, and he has failed to even turn in my counterclaim affidavit. So I asked the court to adjourn my court date for a future date so I can retain proper counsel for the damages that was caused by the tenants. Have a nice day, Miss Snow. And that's from Connie Porter at 12:11 p.m. today. So
Okay.
That's all I know.
Okay. And so Robert, did she contact the court at all?
No, Your Honor, we received no correspondence.
Okay, so this is a non-payment of rent case. Plaintiff is seeking past due rents. Is your client still in the property?
My client has moved out of, physically, they are living elsewhere.
Okay.
However, they had a lot of property left in the house, and I listed that in the emergency motion that I filed. They had stuff like part of a living room couch, stove, refrigerator, bedroom set, and a lot of other items, smaller items, hair, equipment. And let me see here, we have it listed.
So all I want to know, they still in the property?
They've got property there, yes, couple of televisions as well.
Okay.
Clothes, shoes, photographs.
Okay, so let me ask this question here without going. I'm not going to have a hearing without her, but I guess what I'm trying to figure out is this. I'm going to look at the status of this case. This is a non-payment of rent case for the property at 15024 Coram Street, and I have it on the computer here. The parties were before the court, and let me just see what's going on. Just a second. Okay, so the party, this matter started at November the 2nd, 2021. It's a non-payment. The defendants were personally served on 11/23/21. There was a hearing. It was adjourned to February the 15th. Attorney Snow represents, file affirmative defenses, etc. And then I scheduled it for what? For trial. It was scheduled for pre-trial on the 15th. And then today is scheduled for trial.
Yes,
Okay.
I believe Your Honor gave Porter an opportunity to file an answer to my counterclaim.
Okay, so let's do this. Let's do this. I'm gonna give a one-time adjournment. Now, what's the emergency motion? I'm gonna give
Your
a
Honor.
one-time adjournment to allow her a chance to have her attorney present. Okay, and I see you got a motion because she changed the locks.
Oh, Your Honor, she did more than change the locks. Yes, she did change the locks. After at the actual day we were last in court, it appears, upon what I've been told, that Miss Porter left the courtroom and went over to the house, removed some of the defendant's property, put it alongside the side of the house, which I have a picture of it sitting out in the snow. Those were a lot of things out of the child's bedroom, including a television set that looks like it's upside down. The back end of it is showing in that one of the pictures. And then changed the locks. And there was a date when we left last time. The parties were to meet each other, excuse me, on that Saturday, which I believe was either the 17th or it was the 19th of February. We were in the courtroom on the 17th. Porter left after court on the 17th, threw these items out in the snow. And then on the 19th and changed the locks. They were to meet on the 19th and go into the house so they could get their items out. Porter never showed up and sent a lot of rather derogatory emails that are attached. And then a gentleman from our office, who's an inspector, Tim Bishop, went over there on the following Wednesday, I believe it was, which would have been the 23rd or so, the 23rd, and attempted to let them in the house to find out that there was a man living, claiming that he was put in the house by Miss Porter and
Okay.
is allegedly living in the house. I don't know if
Okay,
he's
so
still there.
let me ask this question. First of all, does she still have belongings in the house? And just let the record reflect, I was inclined to adjourn the hearing. I'm looking at the emergency motion, and there are pictures showing items outside the house, text messages that show from Miss Porter to the tenant. It's horrendous. The text message, the language is outrageous.
I don't want to repeat them on the.
Okay,
Yeah.
and we're not, they're filthy. They're very filthy language and statements. Okay, so this is my question. And she says she put the nasty stuff outside, i.e. that's being nicely put. And she got pictures, there are pictures of all her belongings. Okay, counsel, your motion is to allow her to go back into the house. Does she have any other items in the house that you know?
Your Honor, here's where we are. We believed that all of the items that are listed in paragraph 6 of that emergency motion, 3 pieces of a sectional couch in the living room, a 65-inch TV, a 32-inch TV, a new king-size bed, mattress, box springs, bedside table, dresser with mirror, family pictures, clothes, shoes, hair products.
Okay.
Paragraph 6.
Okay.
Flat iron for her hair, facial scrubbing machine, Wi-Fi and router, stove and refrigerator, bookshelf books, alarm system, etc., listed in that paragraph. Yes, we believe. However, in the email I received from Porter today at 12:11 p.m., Porter's indicating that it's been put in, some of this, I don't know all of it or some of it, has been put into the garage. I don't know if that's accurate. And
okay, so
I'm not sure how reliable.
Let me say this. First of all, this hearing was scheduled for 1:30 today. And I'm just going to be straightforward. We have no hearings today scheduled. And so the court made a special effort to be present. I had another hearing. I adjourned another meeting to be present to hear this trial. If Ms. Porter could make it, the right procedure was to contact the court clerk. In addition to she contacted you, but to contact the court clerk to say she was unavailable. She has not contacted this court whatsoever. Now, normally, I was gonna give an adjournment, and I wouldn't have listened to anything you had to say today, Attorney Snow, in all respect, until she was present. But I'm looking at the motion, I'm looking at the pictures, I'm looking at the awful text messages, where she has made a lot of horrible statements. And then just outrageous. And she's done some admissions. It's coming from her phone. She's signing her name. Okay, and it's outside of her house. So that's what I'm inclined to do. I signed the order, and I'm going to indicate you can, if you can, or your investigator can contact her, that being the plaintiff in this matter, Ms. Porter, set up a time for the tenants to go over and remove their items out of the garage. I'm gonna give a hearing for damages only. I mean, it's quite obviously the things were thrown out. And you know, this just always reminds me of that old saying, one person's trash is another man's treasure. And so you may look at something that I find appealing and worthy and say, oh, that's just junk. But there's some sentimental value, or maybe you don't know the worth of it to the person. So I'll say that in this case, if she thought it was trash, it may be, and maybe it was, the tenant's treasure. That's not for her to decide. So I'm going to do the following. I'm going to sign your emergency motion, allowing the tenants to re-enter the property, but I caution you, you need to contact her. They need to have a third party, even if it's the police, to go over and allow them to remove their items. Now, Ms. Roberts, you're present. Ms. Kyla Roberts, okay, I need you to speak up now. Mr. Wyndham?
Yes, ma'am, I'm here.
Was it Miss Wyndham?
Yes, ma'am.
I can't, tell me, I can't hear.
Yes, ma'am, Miss Wyndham.
Okay, so listen carefully to the two of you. Okay, you're doing the right thing. You're speaking with your lawyer. You're letting the court handle the matter. So I'm just going to caution you and say, continue to let that occur. Attorney Snow is working with you. She's going to contact the plaintiff and her investigator, whomever is necessary, to set up a time and date that you can go over and retrieve what other items have not been removed or destroyed. Understand that?
Yes, ma'am.
Yes, ma'am.
Okay, so that means, hold on, that means peacefully. Do not go, you know, if it looks like there's trouble, do not stay, do not fight, retaliate, just leave. And I think Attorney Snow is going to tell you that if you have to get the police to go and watch you to make sure there's no trouble or any danger.
So,
Okay, so I'm going to set it. Okay, just 1 second. Attorney Snow, I just want to finish my thought process. I'm going to set a hearing for damages. Okay. Now she can be present or not be present. And I say this for this reason, based upon the text messages and the photos that were taken of the property. I'm just going to assume, and I hardly ever do this, Ms. Porter didn't want to be present today. She was well aware of all of her horrible messages that she sent and what she had done, allegedly. I'm gonna say at this point. So she wasn't trying to be present. That's why she waited to 12:10 to contact Attorney Snow and say she couldn't be here, because frankly, had she contacted the court, I would have adjourned it. I would not be sitting here almost 2 hours waiting on a case to occur. So I did sign the order. I'm gonna say on the order, I didn't amend anything. Your order just says allowing, it says allowing defendants to change locks, enter the house to remove her belongings. So I'm gonna say this, instead of change locks, I'm just gonna draw a line and say allow them an opportunity to enter the house and remove their belongings, okay? To Ms. Wyndham and Ms. Roberts.
Yes,
Your Honor.
ma'am.
Okay, go
A
ahead.
couple of things. Can I raise? The locks have been changed. They cannot enter the house without someone changing the locks. I'm concerned the police will try to stop them from
Okay, no.
going in.
No, what I'm saying is this, counsel, what needs to take place, you've indicated that the plaintiff has sent you an email and she's indicated that their items are in a garage, right?
Yes,
So
I
what
think
I'm
we
asking-
need to,
Go ahead.
I think that perhaps it should say house and garage, wherever
Okay,
I
allow
say.
defendants to enter house or garage to remove her belongings. Okay, so I put garage in. You can send me another order if you want. And
Nope.
remove her belongings and finding plaintiff violated prior court order. Okay, so I did make that notation. I initialed that. And then I'm gonna have Robert put a seal on the back of it and give them a copy. They can pick it up. If they choose, come down to the court and pick it up, we can mail it, but probably pick it up would be the soonest. Now, if that's okay with my court clerk. And then what else? So they can do that. Let's set a new hearing date. And that's for damages only. Just a second. So I did sign the order. Let's set a hearing date. I'll set it in 2 weeks. Well, let's set it within, I'll set it within 2 weeks, and we're gonna do the hearing with or without her. Because as I indicated, based on what I've read, she probably was not trying to get here today. Okay, let's do this. Robert, what about April the 1st? That's a Friday. We're jam-packed, but we're trying to find April the 1st, 1:30. I know, is that a date you can make, Attorney Snow?
If it's at 1:30, Your Honor, yeah, I'll make it. It's a lakeshore day, but we can do that.
Robert?
We got a pretty heavy day that day. Is it possible
Okay.
maybe we can do it that Monday?
Okay, just tell me, is the court open April 4th?
Yes, court will be open on April the 4th. We do have a little bit of time available to be able to do it on 1:30.
Okay.
On the 4th, Your Honor, are you guys talking about the 4th at 1:30?
Yes,
That's fine.
April the 4th at 1:30. Okay, so to Ms. Roberts and Ms. Wyndham, that's for gonna be a damage hearing.
Now,
Okay.
Your Honor, I want to be, I'm a little bit worried about letting Ms. Porter know. I hear what Your Honor's saying, that you want her there.
Want her where, in court?
No, at the house
Well,
when
she
they
doesn't
try
have
to
to be at the
remove their
house.
items.
Someone, she doesn't have to be there. Someone,
Okay.
as long as someone is there. And you can write it in the order and I'll sign it. She doesn't have to be there. What we're asking her to do is this, what the court is ordering her to do is to allow access to the house and the garage for the tenants to remove their items, allow access. Okay, so she
And
doesn't have
Judge,
to be there. But I caution, allow access to the house and garage. She doesn't have to be there. I can't order her not to be there, but she doesn't have to be there. But I will caution the tenants that they need the police or a third party, and probably the police, to go over and help them. Okay,
I was
because
just
you
gonna
don't want
say,
to
Judge,
have.
can you include that in the order? Because when you had us scheduled to go that Saturday, the police basically said if you would have had an order for us to go in, they would have did it. So I don't know if they need to be included on that, because I tried to show them the last one and they said that it wasn't up to date. So I don't know if they need
didn't have
something
an order.
written by you. Yeah.
Okay, I'm gonna
I don't
ask
know if they
Attorney
need.
Snow, are you familiar with that? Because I don't know if I can order the police.
No,
But
Your Honor,
I
I think
can't.
what she's talking about is they wanted an order showing that they were supposed to go in on the Saturday.
oh,
Yeah.
that the
And-
tenants were supposed to go in.
Right, and we didn't have an order. We talked about it. Your Honor made a verbal order. We
Okay.
never reduced it to writing at that
Okay, so
time.
let's do this. This is what I'm gonna request. I'm gonna request Attorney Snow if she can contact Ms. Porter and ask her for a date and time that the parties can go in. Okay, I'm gonna ask Ms. Roberts and Ms. Wyndham to give Attorney Snow a couple of dates or times that you believe you'll be able to go with the trailer or truck and remove your items. Okay, once Attorney Snow confirms it, then I'll sign the order.
Your Honor,
Yeah.
I will do that,
Mhm.
but my concern is that Miss Porter seems to have a pattern and practice of doing things right after hearings and right after she's been notified of the court's position. I am worried, we're in a bind now. If she has moved the property into the garage and has locked the garage, I'm presuming there's not a key like there would be to the door of a house. I don't know how hard it is for a locksmith to change the key on the garage. It is our position.
Okay, but let me ask this. Why do you need to change the key? They don't have a place to take their items?
Your Honor, the garage, she put the item, she's telling me, Porter is telling me that she put the items in the garage. If she shut the garage door and it's locked, we can't get in there unless she has a garage door opener
But what
or a
I'm
key to
saying,
the
what I'm
garage.
saying is this, contact Miss Porter. You have a court order saying that, one, she's to schedule a time that the tenants can come over and remove their items. And then the tenants should give you 3 or 4 times when they can come. And she's got to allow them an opportunity to get their things. That means either have somebody there present or have the door, or have someone present to allow them in or give them a key.
Does Your Honor want to write that somewhere on the order I sent over? That she is ordered to schedule a time, because I think she's going to give me the bum's rush.
Okay, and then let's do this. You can come back on Friday after you've spoken to her and let me know what the situation is. Okay, so at the bottom of it, I'm gonna put 1. Miss Porter to allow tenants to set a time to remove their items from the garage and house. Okay, what else?
Thank you.
Okay. I'm gonna put a time convenient for tenants, okay? So what the tenants
Thank
are
you.
gonna do is give Attorney Snow a couple of options. I can do it on Monday at 5 o'clock. I can do it on Tuesday, or whatever your times are, that you'll have help and you'll have a truck or a trailer to move your items. And then council is going to ask Ms. Porter to select 1 or 2 of those times and then allow the doors to be open. Ms. Porter to allow tenants to set a time to remove their items from garage and house. Okay, 2, she is not to interfere with the tenants, period. Now, what else?
Your Honor, if she doesn't do any of that, can my clients then could go in and have access if they have to change the locks and provide her with a key afterwards? That's the only other option I see.
So how are they gonna do? They gonna contact the police and allow access to remove the locks?
Your Honor, I would say we'd remove the locks and then contact the police and have
Okay,
the court
but let
order.
me just say this, Attorney Snow, this is the problem. I can tell the tenants, go on over there and remove the locks. Guess what? You got people walking up on the property, moving the locks. You got somebody's in the house thinking they're breaking. It's a
That's true.
situation
I see what you're saying.
set up for a major problem.
Yeah, I see what you're
It could
saying.
be an accident. I see you out there taking the lock off my door. I think you're breaking in. No,
Okay,
I think that they need to contact the police and
okay,
take the order over. Do not go over there and start taking anything off anybody's property. Understand that, Ms. Roberts? And Ms. Wyndham, once you
Yes,
are
ma'am.
gone, okay, once you're gone from the property, unfortunately, she evicted you, self-help. Do not go over there because you are putting yourself in jeopardy. So no, I'm not going to tell you go over
Okay.
and start dismantling a lock. I'm going to say that failure to allow tenants, she's going to be held in contempt. She, Ms. Porter, will be held into contempt. And she already is. Of court, okay?
Thank you.
So, okay, so let's do this. Attorney Snow is gonna set up some times. I'm gonna reschedule it for Friday 11:30, Attorney Snow. Let's get a time set Friday, 11:30. You can email her and tell her. Friday, 11:30. She can be present or not. We're gonna set a future hearing for damages. Robert, what day did you give me for damages?
April 4th, 1:30 PM, Your Honor.
April the 4th, 1:30 PM. At that time, I'll make a decision, give a judgment. They can always garnish her. She's working. That's a good thing. All right, you all have.
Your Honor,
Yeah.
what are we, just so I'm clear in what I tell Porter, rescheduling for Friday at 11:30 for the purpose of,
Of determining when the tenants can access the property. So
okay,
that's Friday, 11:30, for a time for tenants to access the property. Okay, so at that time, to the tenants, you'll know when you can go in and get your property, all right? And then April the 14th at 1:30 damages, present or not. I'm proceeding with the hearing. Okay, you all have a great day. Thank you.
thank you.
Okay, all right.